or you just get the thread by text?
I think I could get a Google Bite.
Okay, so in that Google Meet invite, you're going to see a memorandum of law called Haynes versus Kerner. And that's a federal case that you can file in your case. That's why I put it there. That says to the judge that although you're not an attorney, you're pro se, the judge should look at your motion for the spirit of what you're requesting. If you made the wrong request, the judge realizes what request you were trying to make, the judge should see it as that a request. If you make the wrong motion, that the judge should see your motion for the correct motion, and it gives the judge teeth, because a lot of times the judge has to be non-biased. He's sitting there, and you're allowed to, you or the other party is allowed to have a bad attorney. You can have a bad barber, you can have a bad dentist. It's your choice to have somebody bad or somebody good, or have nobody at all. So if you go before a judge and the judge knows what's going on in your case, he doesn't have the power to help you just because you're doing bad in court. That's your right to do bad or your right to do good. However, if you give him this memorandum of law, Haynes versus Kerner, it's giving him permission and citing the other side that you now giving the judge authority to help you. And I've used it in my case, and it works. So it's called Haynes versus Kerner.
Paperwork, or do I need to just say it?
You just file it on your case. Just take it off the thing, and you file in your case as a memorandum of law. The next time you make a motion to go to court, you add that as a document. And before you start your case, Your Honor, before we begin on the motion for contempt or the motion, I'd like you to take judicial notice of the motion, the memorandum of law that I filed, which is Haynes versus Kerner, that gives you the authority and permission to help me, although I'm pro se, and to look at what I'm trying to say in the spirit of what I'm trying to say and help me along the way. Although you can't give me legal advice, Your Honor, I recognize that, but this federal case gives you the authority to look at what I'm doing and understand what I'm doing from the spirit of what my attempt is.
I'm good. Let's move on to someone else.
Okay. John S. Go ahead, ask your question, John.
Thank you.
Attorney Elias, again, thank you.
Thank you.
Can you give some general advice? Many of us deal with situations with visitation, child custody, time sharing, etc., that is not being followed. Do you have any advice how to document the violations to be presented in court?
I would, what I always recommend any client of mine that's going through a divorce, to start a daily diary, a journal, what time, your whole day, your interaction with your children, what time you made first contact, what time you made contact with the other parent, what was the reply. Have a journal. Because when you prepare your motion, John, when you prepare your paperwork in front of the court, you can incorporate that into your motions, and you have your backup, as with the other side's not going to have it. So I always, in every contested divorce that I do, I tell my clients, start a journal as of today. And the time, the date, as to each and every event that is occurring that is a significant event in your life or in your child's life, and your interaction with the other spouse. And when you come into court, you can incorporate that into any motion that you file, and you have specifics. On such a date, at such a time, I called mom. She wouldn't let me speak to my child. On such a date, such a time, I had court-ordered time sharing. The mom refused to allow me time sharing. You have specific facts in front of a judge, not just general allegations, and that will compel a court to be more inclined to grant any motion that you file, John.
That's great advice.